And I want to go through a contract with you guys just to touch base. And a lot of you, this is going to be, just redundant, but I think that it's important from time to time that we touch base on what mistakes that we're seeing on contracts, especially in a time where we're so aggressive with competitive offers. When you make mistakes on your contracts, that will hurt you with getting your buyer's offer considered. But also as a listing agent, I want you guys to be salty enough to understand what the pitfalls are if you don't catch them during contract. So I'm going to share my screen with you guys again. Let me get over to this one. All right. So I've pulled up just a regular purchase and sale agreement. All right. So the things to be looking out for, everyone can see purchase and sale agreement on the screen. Okay, great. So obviously you want to have the correct date. Now, the reason I want to talk about date real quick is your schedule is not always copacetic with your client's schedule. Could be a Friday, could be a Saturday you're doing this and they don't get to you until late that night and you can't present until the next day. Just be aware that all the contract documents, whatever it's dated when you do the contract, it's fine if it's the 29th and you send it on the 30th, but your timeline has to coincide with giving that agent enough time to review. I know it's kind of a pain in the butt to update contracts. I use zip forms. I don't use RemiDocs. The reason I use zip forms is, guys, this was the best thing to use before even RemiDocs came up. So use what you're comfortable with. I pay a lot of money for zip forms. I do this on the side. I think it's like $200 a year, but I do like it for ease of use for me, but also just to keep everything recorded correctly. So July 30th, we talked about the date. Make sure that you have the correct address. And I know that sounds silly, but sometimes it doesn't populate correctly. So always check that. Make sure the MLS number is in there or your FMLS number. Make sure that the tax parcel ID number is in there. You get those all off the listing. I use this legal definition for every single contract. You can get the legal definitions by just emailing the closing attorney. Same thing for all of your listings. Have the legal descriptions as one of the documents that you load up into RemiDocs. Because if you, as a listing agent, already have this loaded, the buyer's agent, if they're good and experienced, they're going to be asking for a legal description either from you or the attorney or a closing attorney. So this is a hack, guys. You can be brand new agent and look like an experienced agent as long as you throw in that legal description and you have that in your contract documents when you present the contract. Okay, next up, purchase price. That's pretty basic. Closing costs, always put something in there, 0, NA, whatever you want. Closing costs, closing date. Guys, I have August 31st on here. Don't ever close on the last day. Don't ever close on a Monday. The reason being the last day of the month, it is so crazy for the closing attorneys. And if you were there on Wednesday for cocktails and closers, Colin said, guys, the title searches, everything's taking longer. So the optimum days to close are going to be Tuesday, Wednesday, Thursday. Not Friday, not Monday. Because if you're a buyer and you're scheduled to close on a Friday and something happens to your loan and you've got the moving trucks and everything scheduled to move you on Saturday, you are screwed if something happens with the loan, right? Because now your deposit for the mover, all that stuff gets messed up. So try to close Tuesday, Wednesday, Thursdays. And then if it's a holiday weekend, don't ever close on a Tuesday or a Monday. Close on that Wednesday or Thursday. So always be cognizant of that. You also, at the closing is when you want to take possession if you're the buyer, but know that they may negotiate some days after closing. Now, make sure you are executing a temporary occupancy agreement if they are in the house for even 24 hours. It's protecting your buyer, and your seller, okay? It's very descriptive of who's responsible for what, The seller no longer is responsible for homeowners insurance for the house, but they are responsible for contents insurance. The buyer is not going to be able to close without a deck page, so they're responsible for insuring that house as soon as they close. But know that you make sure you got that temporary occupancy attached to this agreement if they are staying. At EXP, we do not hold earnest money. Have your closing attorney hold it. Do not have a small broker, boutique broker, ever hold your earnest money. I'm okay if Keller Williams wants to hold it. I'm okay if Harry Norman. I'm okay if Berkshire Hathaway. Any of the big operators, I'm fine. And the reason I'm fine with that is because they have more checks and balances with their legal team and their processes. I do not trust a broker who's also the agent of their own brokerage holding your earnest money, guys. I just don't trust it, and neither should you, because what will happen if there is a dispute, there's no third party that is completely out of the loop. Where if you have your attorney hold it, they've got their legal license and they've got a whole bunch of auditing involved, right? So have your closing attorney hold it, number one. Number two, if it's a big operator and you're representing the listing, it's fine to allow the bigger operators hold earnest money. Any questions on that? I see something in the chat. Let me make sure that I don't have any questions. I pay $12 a month to get legal descriptions, legals. So yes, you can pay for it too if you're writing a lot of contracts on Saturdays and Sundays, but eliminate some of those costs and you can have the closing attorney do it too for you. Earnest money, back to earnest money. Right now in this environment, you're going to have to go more than 1%. I always counsel my buyers, 1% is the minimum earnest money. If you want this contract and you're in a multiple offer situation, you may advise them to put their down payment in as earnest money. So minimum right now, I'm doing 2% minimum, but I am encouraging them to go a lot higher, depending upon the contract, depending upon the buyer. Due diligence, make sure you're filling this in. On a normal time period, due diligence is 10 to 12 days. Maximum 14. If you're doing commercial like Catherine does, it's 90, but due diligence, you have to be aware that needs to be a real tight time frame during these very aggressive seller times. Now, remember, during due diligence, you can always extend due diligence. You can always add additional terms to your contract. You can renegotiate anything during due diligence. But to get the house under contract, you might want to go lower. If they have a backup offer, it's going to be a lot harder to negotiate any terms during due diligence. But make sure that's filled out. Lead-based paint, if it was built before 1978, you have to check that was built. In this option money area, you always want to throw in, anytime there's a blank like that, just NA, not applicable, okay, in this contract. If you're doing a counter, it's not NA. The counter, it's no change or NC in any of the blanks. Very important difference, guys. NA means non-applicable, or just put a dash, okay? If you're confused, you forget, put a dash in that. But in the counter offers, you either fill it out completely or you put in no change. Sorry, what was recommended for the DD period on residential? 7 at the max right now during a highly aggressive seller's market. In a normal market, it's between 10 and 14, depending upon what's going on. Your brokerage, you're filling out. EXP Realty is your brokerage. Whoever the listing agent is here. You are representing your client as a client. You check here. The other agents representing their client. Now, if you guys are buying another EXP property, I'm going to throw this out to you guys. If the other broker was EXP in this form, what would you do? They're a designated agent. Okay, even though they're not on your team, you don't know them at all, you're still going to have to put that designated agent in there because they're the same broker. Always fill out this blank here. Material relationship, none. Okay. Time limit of offer. My biggest pet peeve of this. And if everyone has not taken my etiquette class in EXP Workplace University, please go search for it and take it. It's a requirement. If you're going to do any real estate business, take my etiquette class. Time limit of the offer needs to be no less than 24 hours. And that's from 24 hours of receipt, guys, not from when you guys talk to your client and had this filled out. So if you're talking to your client at 5 and you know it's going to take them 2 hours to get the contract back to you, make sure you're given enough time for that agent and that client to review. So 24 hours is minimum. If you know there's a multiple offer scenario, you may want to go further and give them 48 hours so that they don't feel rushed. You look like the good agent, and people want to work with the good agents. Because remember, guys, you're working cooperatively. These guys are not your enemies. They're your friends. Some of them are jerks, and we have to deal with some jerks every once in a while, but think of them all as your friends and that you want to coach them up if they don't know what they're doing yet. All right, now we're down to the exhibits and the special steps. In a very aggressive market, you keep your contracts clean. There's nothing in the special stipulation area except for this specific stip. Deadline dates. With experience, you'll know that working on a Friday, Saturday, Sunday night, as well as a holiday, totally sucks. And the other agent will respect you for putting this in here unless her client is like, now I want to keep calendar dates. The deadline dates, this allows you guys to have lives and not having to leave special events to negotiate inspection amendments at 11:59 or sending off terminations at 11:59 or 11:50. Hopefully you're sending them a little earlier. So the deadline dates I always put in there. If you find an issue or a client wants something more, look at that special stip sheet because I'm sure I've got it. Professional cleaning of the house. You want to make sure that the HVAC is serviced and clean. They're all in that special stip stock, and it's also been vetted by EXP as well as an attorney. On your exhibits, always make sure that if you're in an association, you have your community association agreement, you have your seller's disclosure, you have your legal description, you've got your seller's property disclosure, you've got your lender pre-approval letter. You also have the EXP affiliated disclosure, affiliated business disclosure. Now, the way I explain the affiliated business disclosure is very simple. To comply with RESPA, I just need you guys to sign this. I'm not making any money off these vendors, but EXP or someone up the line may have made a marketing arrangement with these companies. I haven't. Sign it. Never a problem. But make sure those are also, they're all in there. Anything, right? You guys can put another page onto your special steps if you need to add amendments. But the key is in this environment, clean, no mistakes. Have someone else review it if you need to. Additional steps box is right here. You can always mark that if you've got additional steps to add. Make sure that your client's information is in here without their email. The reason you want to leave out their personal information is the broker needs to have their personal information on your buyer's brokerage agreement in case you guys, God forbid something happens to you, the broker can get a hold of your client. You do not want to be giving this information to your competition. Always go into the tax records and fill out the seller's information, just their name, okay? Always complete the information for your broker on the other side. So make sure that's done. And then on every single exhibit that you use, I'm going to go through one more very important exhibit, and that's your financing contingency, okay? So let's go into our conventional loan. The way that you show inexperience are 3 ways. It's what they're financing. 81% of the loan is what they're financing. Don't put their down payment in this block. Next up, you want to make sure that you're giving them the 30 years, 15 years, 7 years, whatever the client's loan is about. Shows that you've done your homework and you're working with someone. The percentage you put in this block is directly associated with the market fluctuations. They may be pre-approved at a loan at 3.2, 3.5%. But if it's a crazy market, if they were to fluctuate over 3.5%, for example, in this example, that buyer could get out of the contract with their earnest money. So you want to, as an aggressive buyer's agent, if you want this deal, you go a 1/4 point above what the loan officer has given them. 1/4 point above will be fine. Okay, so understand that piece. so that you can explain it to your buyer as well. They'll be like, well, my interest rate is 3.25. Why are you putting 3.5 in there? Mr. Buyer, the reason I put it in higher is I want to make sure the selling agent understands, or the listing agent understands, that if markets fluctuate, we still can afford, and we're not going to get out of this contract. Now, the other thing that I see rookies do is not fill in the approved lenders. Use the one that gave you the pre-approval for. And then if there's another one they're shopping, go ahead and throw it in there. It just saves you time down the road in case they want to change. Financing and appraisal. Which one comes first, the chicken or the egg, guys? You have your due diligence, you have your appraisal, which comes first, then you have your financing. If you go in there and you give me a 21-day financing contingency and a 28-day appraisal contingency, immediately I'm telling my client, the seller, you're an idiot. Let's take this. The reason being, the appraisal has to happen first, guys, right? So your appraisal right now, I'd do 14 to 18 days, but I would have had a conversation with my lender to make sure that they can meet that. And I would also have my final financing contingency about 21 to 26. The appraisal stuff is crazy right now. You may or may not need this financing contingency. Susan and I just did a contract yesterday with a buyer and we pulled it completely. Now, if you pull it completely, you cannot have a contingency and just tell your client that if during due diligence, they want to terminate, they get their earnest money back, but after due diligence, they have no contingencies. Or you can provide them this form with 0 in your appraisal and 0 in your final financing. It's not cash, so I always recommend still giving a pre-approval letter.
I have a question on this financing contingency form. It has in there that you have to notify once the buyer make application. So you have to notify the listing agent, the seller, that the buyer has. But what I find that a lot of lenders do not tell you once the buyer has made that. The earnest money, the listing agent can always say, you never notify me that the buyer made application. Is that an opportunity for the seller to get the earnest money because the buyer did not do something that was in the contract?
That was a very good question on Andrew's part. Number one, brokers will never ever go to court over earnest money unless it's like 200, 300,000, right? So the person who's holding that earnest money is going to be the final say. So you want to hold it with a broker that has experience, but also your closing attorney would be my recommendation. Number two, that's a little thing that they may be able to fight, but I'm glad you asked this question because in my buyer's brokerage agreements, I make it a special stipulation, guys, that the buyer agrees to make full loan application within 4 days of binding agreement. If they don't do that and we don't have this conversation with our buyers and set expectations appropriately, they don't understand. I can't renegotiate anything after due diligence. I have buyer's agents come to me all the time and say, Collette, we couldn't get our appraisal in, they're backed up. And I'm like, it's not my problem. It's your problem. You didn't manage your buyer's expectations appropriately. Why would I, as the seller, change any of the timelines? That puts me in a bad position, right? You have no leverage. I have leverage now. And that's what negotiations is all about. I'm going to make a big caveat here, guys. That's why you treat your agents, your co-op agents, with the utmost level of respect. Because there's been times where I have granted this. And you know why? Because this agent's been amazing. Or there's a special circumstance in the person's life that made it, something weird happen. You never know until you have dialogue with all parties and you only have information from your seller. They only have information from their buyer. So having this open dialogue of respect and professionalism will serve you well to closing. I have seen people walk from deals with leaving their earnest money on the table. They got their feelings hurt or they took something out of context. So you're never closed until you're sitting at that closing table, and still it could be difficult. By doing your contracts really cleanly, without mistakes, operating at a high level of professionalism, you're going to mitigate 90% of the issues, but you're still got to be open to those 10% that you're going to have to deal with. The things you can control are your contracts in the four corners of that contract. And know that, the earnest money is always going to be the thing that is questionable, that people will try to get, and they will also sue you guys. So don't forget that. If you guys make mistakes, your E&O insurance will help cover things, but you still have deductibles. So it's really important. I don't want to scare you, but don't operate haphazardly. Your license is too important. Changes in contracts and inspection items, guys, those are like the two things you should always be looking to CE credit for. Those are so important. So the more you can learn the inspection stuff and the contract stuff, the better you'll be able to advise your clients, the more knowledge you'll have and the more trust they'll have in you. When you're advising your clients about the financing contingency, first and foremost, okay? This is not the for sale of another property or a lease of another property. You have to disclose by adding an additional exhibit if there's another layer regarding the sale or lease of those properties as being a contingency to getting them financing, okay? Now, a lot of sellers, a lot of buyers take the risk and they say, I'm not gonna put this contingency on for the sale of my home, meaning if the house doesn't sell, the lender can't finance them, they lose their earnest money. So you have to make sure you're having both contingencies attached to the contract if they're both valid, okay? Now, what Dawn's talking about is you've got your due diligence time period. Now remember, guys, your due diligence time period, you can negotiate anything, you can change anything, and all of this is stacked up, obviously, with what their personal situation with the sale of their home is. If they tried to get another house under contract and they're wanting to thread the needle a bit, and maybe, they know that during due diligence, the final financing contingency for their buyer on the sale of their house will expire. So they know if it's going to be solid, they'll get final clear to close. So they don't need to make it contingent. These are all options for a buyer to take risk. Okay. You as the buyer's agent need to correctly present the risks. Due diligence is due diligence. You can get out for any reason. Silver bullet. Appraisal is appraisal. You can only get out if the seller doesn't want to negotiate if it comes low. It's the only way you can get out. Clear to close or final financing contingency, the only way you can get out is if something crazy happened, like they lost their job or someone died and it substantially changed their income or debt to income level. If they bought a car, if they open a new credit card, if they buy a refrigerator, furniture, whatever, that will change their debt to income ratio. So guys, you have to counsel your buyers not to do anything for those 30 days. Because if they do and they change their debt to income ratio, that financing contingency doesn't cover them. They lose their earnest money, okay? Now, the final contingency, if they've put it in there, up to the day of close or whatever day they put in, is the sale or lease of their property. You can put it in there. It's up to the day of closing on the house because they may close on their house on the 20th, but they're closing on this house on the 30th. So it's really just contingent till the 20th. So you can stack that on top of it. The more contingencies you have, the less likely you will get the contract past the listing agent if there's a multiple offer scenario. The longer a house sits on the market, the more negotiable they are, both in terms and sometimes price, depending upon the motivation of that seller. Did that answer your question, Don? Did that make it more clear? This is why we as listing agents never accept contracts that are contingent on another sale in a multiple offer situation, because we can't see what their buyer is doing. We have no idea what's going on with their loan. We have no idea if they're going to be reasonable during inspection. We don't know if they've made loan application. We have no vision into that. So that's where the confusion lies, right? The buyer can make the contingencies however they want, dependent upon their personal financial situation. Next thing I want to bring up, guys, is agent violations. All right. So how many of Irna and I just dealt with this last week? We were writing a contract for our investor. We went through all this time, got the contract together, presented it. Oh, we're under contract. We just have it as active because we want backup offers. Well, that's a violation. That is a huge violation, guys. Once you go under contract, you have to, within 24 hours, change it in the system. Within FMLS, okay, there's that little police icon. Does everyone know what I'm talking about? Because I will share my screen if you don't. Let me share it with you guys real quick. You can see right here, this police icon, right? Right here is where you would report a problem with the listing. For instance, if it's saying it's active and it's not, it's under contract, and then you're going to write here, hey, it's not active, right? I've had people give violations on me because they've, seen my coming soon advertising and I don't have it in there yet. So it is your responsibility to go ahead and report these guys. If you put the wrong school in, maybe someone would be nice enough to tell you, or even the wrong area. But sometimes I see that and I'm like, that's an opportunity when it expires. I'm going to call that seller and tell them how dumb their agent is. It all depends, right? But definitely put it in there if they're violating the active status. So text them, email them, call them. If they're not responding to your multiple offer to say they received it, be super nice, text them, call them, email them. If they still haven't responded, call the broker. And when you talk to the broker, the script is, hey, I'm just calling because I'm really concerned. This listing, I sent them all on offer. I haven't received a confirmation that she received it. I know she's a great agent. Is she okay? That just dilutes the issue, the situation, right? It makes the broker say, okay, they're not being a jerk. They're not going to call me out. This is not going to be a problem. And then they help you 9 times out of 10.